So you can see that we have this wide range of terms in state constitutions that affect the rights of people with developmental disabilities to vote. In addition to that, we've got state laws, and these state laws sometimes contradict or ignore the provisions in the state constitutions. And we can look at a couple of examples from two states where this state constitutional provision was challenged, or the state laws were challenged. One of them was in Maine. In Maine, the Constitution, in the 1800s, right, it disenfranchised, quote, paupers and persons under guardianship. Well, in 1965, that was amended, updated a little bit, to deny the right to vote to persons who are under guardianship for reasons of mental illness. That's still in the Maine Constitution right now. For about 20 years, the Maine Secretary of State interpreted this to mean that only people who are under guardianship because of some kind of psychiatric mental illness couldn't vote. They said that's how you should interpret this Constitution. But this constitutional provision and even that interpretation was contradicted by state laws of guardianship. The probate judges in Maine who established guardianships were supposed to, according to their law, only establish guardianships that limited the powers to the extent necessitated by the incapacitated person's actual mental and adaptive limitations. So some probate judges in Maine were specifically saying that people under guardianship could vote. Others were saying you couldn't. And this applied to people with developmental disabilities as well as people with mental illnesses. In Maine, a federal district court judge held in 2001 that Maine's laws violate the federal Constitution. They violate due process because you can't take away fundamental liberties like voting from anyone without ensuring fundamental fairness, a procedure that protects that right in the most kind of basic ways. And when they looked at how the state of Maine was depriving people of the capacity to vote, and when they looked at the guardianship procedures there, the court held that they didn't give people adequate notice before those rights might be taken away, that they didn't have an opportunity to be heard, they didn't necessarily have the right to be counseled in those guardianship procedures. They might lose this basic right, so those rights could be taken away without due process. So that violated the due process clause. The district court in Maine also heard that they violated the Equal Protection Clause. Because a restriction on voting rights restricts a fundamental right, the laws that states pass are subject to really carefully scrutiny. They have to promote a compelling state interest, and they have to be written in such a way that they don't do anything more than just protect that interest. They can't be overbroad. And here, the court accepted there was a compelling interest, right? You want to make sure that those who cast the vote understand that they're casting a vote, but was it really narrowly tailored enough just to make sure that those who don't understand what they're doing don't do it? And the court held no, it wasn't. Because of the way that law was written, you have people who were mentally incapacitated, who were not under guardianship, who could not understand what they were doing, and their right to vote wasn't taken away. You had people who were in guardianships for mental illness, but their mental illness didn't preclude them from understanding what they were doing when they were voting, and their rights were taken away. So the court in Maine held that that was a violation of the federal Constitution, the way Maine's laws were written.